Hello, everybody. This is Klint Macro with Firearms Owners Against Crime Institute for Legal, Legislative, and Educational Action. I'm here with our president, Jim Stoker, and our counsel, Joshua Prince, who has some pretty exciting news about something he experienced this very morning.
So, Josh, you did us a favor, obviously going over to the Philadelphia case, the Supreme Court, hearing the argument that GOA had for against Philadelphia for their overstep and what we think they're trying to regulate privately manufactured firearms. And I understand your opinion of it that they tried to really spread the wealth here, going after preemption in whole. So it's important that you be there. We did file an amicus brief to support the GOA case, which you were obviously chief counsel on and took the step for that for us. So I'd appreciate you just take a minute here and explain to everybody exactly what your opinion is of what happened this morning so we can kind of spread the knowledge.
Sure. So it was really interesting because a number of the justices really posed questions that neither side could fully answer. They were really looking at the text of 6120. In fact, Justice Donahue started out very clearly by asking questions that were specific to the end of Section 6120, where it talks about being in relation to carry or transport consistent with the laws of the Commonwealth, and that it was clear from her question she felt that modified the entirety of the text, and thus, unless a firearm was being transported or carried consistent with the laws of the Commonwealth, there was no preemption beyond that, which is contrary to the Pennsylvania Supreme Court's prior precedents in Ortiz, that most of our viewers have heard about from back in 1996, where the Pennsylvania Supreme Court previously declared that our preemption code, Section 6120, preempted the city of Philadelphia from regulating in any manner firearms and ammunition. And in that situation, it involved assault, what they termed assault weapons, and some other items. What was interesting was watching how Justice Donahue was contending that in Ortiz, the court really didn't interpret any of the language of 6120. They just issued a decision saying what it meant, which is kind of defied by the decision itself and doesn't make a lot of sense. But historically, Justice Donahue has not been a supporter of our preemption code or our Second Amendment rights. Justice Brobson played a pivotal role during argument, raising a number of issues, including the fact that, in his opinion, or at least one argument that exists, was that the language Justice Donahue kept hanging her hat on with regards to carrier transport would be in relation to ammunition and ammunition components. For some of the listeners who may not be aware, Section 6120 over eons, I'll say, but I guess it's now probably close to 50 years, if not, well, it's probably more than 50 years, somewhere around there, has been in existence and has been changed over time. And ammunition components, and that latter phraseology at the end of the sentence didn't exist under the prior versions of 6120. So Justice Brobson was also saying that it wouldn't make much sense in the initial language of 6120, where it talks about ownership, possession, transfer, transport, to say that it would only transport be protected if being transported for lawful purpose, a double transport phraseology. So a number of the justices did seem to agree with Justice Brobson on that point. Also, Justice Brobson raised the fact that, in his opinion, there were what he called three pillars to possession. And what he got from the city was acknowledgement that one of those pillars is the ability to transfer. So basically, he was using the word transfer in the context of, I want to give you a firearm. The second context was where you purchase a firearm from a federal firearms licensee, and the third being where you manufacture a firearm. And that those are, again, what he called the three pillars of possession. And since Section 6120 talks about possession in this scenario, it seemed as though he felt that 6120 did clearly preempt the city of Philadelphia from being able to regulate the manufacture of firearms. Justice Dougherty had significant issue because of the fact that the word manufacture was not specified in Section 6120 and whether it would encompass that. Now, that leads into, I should say, one of the issues we briefed was what is called field preemption. So, taking a step back, there are three forms of preemption in the Commonwealth. One is conflict preemption, where basically something in the law conflicts with another provision of the law and which is preempting which. Not an issue in this case. The second form of preemption is what's called express preemption, which is where there is an express statute or provision that says certain things are preempted. So in our situation, Section 6120 would be an express preemption provision. The third form of preemption, and the main focus of the amicus brief we submitted, is what's called field preemption. In relation to field preemption, it's where the General Assembly has so occupied the field, and it doesn't have to be in relation to firearms. It can be, for example, in relation to the public utility commissions and public utilities. It can be in relation to alcohol. There was a third one, I forget what it was, where the Pennsylvania Supreme Court has previously said, just based on the totality of law enacted by the General Assembly, even in the absence of an express preemption provision, it constitutes field preemption, that the General Assembly wants to be the only entity that will regulate in this field. So we had focused on that. Unfortunately, that issue didn't get well discussed today. To the extent it was discussed, especially by the city, they were trying to contend that the express preemption provision in Section 6120 didn't itself constitute field preemption. And I was like, well, duh, it's an express preemption provision. It wouldn't, be itself a field preemption provision. In our brief, we took a lot of time to review the breadth of the Uniform Firearms Act and how the General Assembly wanted, just alone in the Uniform Firearms Act, to preempt any form of regulation beyond it. However, we went well beyond that. We also documented the range protection statutes that the General Assembly has enacted, a number of crimes code provisions, such as shooting into occupied structures or even shooting across a cemetery. Believe it or not, there is a specific provision under Pennsylvania law that makes that a crime. We also reviewed the hunting laws and the totality of the laws and regulations just as they relate to hunting, showing that the issue of firearms is not just simply addressed in the UFA, the Uniform Firearms Act, but across a number of different titles and beyond just simply the crimes code here in Pennsylvania. I am hopeful that the court will spend some time looking at our amicus brief because, as the listeners may remember, I believe I had done a debrief of the Crawford oral argument when the PA Supreme Court heard that case where the city of Philadelphia had challenged the constitutionality of our preemption code. And in that decision, the Pennsylvania Supreme Court actually laid the foundation for a field preemption argument. They acknowledged the breadth of the Uniform Firearms Act and, consistent with its own binding precedent, basically said it meets this threshold, but didn't take the next step to say, we find there's field preemption, because in that case, it wasn't pertinent to the decision and it would have just been dicta outside the scope of any holding if they had held it. But nevertheless, the foundation was set there. The reason why I think it was important for field preemption to be addressed is because it would have addressed Justice Dougherty's concern about the word manufacture not being used in Section 6120. One of the other arguments I wish had been made is, at what point have you utilized enough words to establish that you intend to prohibit in all forms any form of regulation? I think the General Assembly, in utilizing the words it did, possession, transfer, transport, ownership, was intending to utilize such broad categories to encompass everything that would exist. That exact argument, unfortunately, was not made today. But nevertheless, I do think that it's likely that we will see a decision from the PA Supreme Court that may decide not to address the field preemption issue if enough of the justices are convinced, based on Justice Brobson's argument, that as a pillar of possession, manufacturers included in that, and they just decided on the express preemption provision. If that's what they do, I am sure in the future we will see cases where the field preemption issue will be addressed. I know that there are two cases I'm involved in that the court stayed, first initially in relation to its Crawford decision, and after it issued its decision in Crawford, it then restayed them pending its decision here in the GOA case. That is the Pittsburgh case that Firearm Owners Against Crime had litigated successfully against all four of the ordinances. I guess it was three ordinances that the city of Pittsburgh had passed back in 2019. The other case, Armstrong, deals with the city of Philadelphia trying to civilly prosecute someone for not disclosing a lost stolen firearm. I don't think in either of those cases they would necessitate addressing field preemption. However, I'm sure the listeners remember that FOAC was successful recently in Montgomery County initially, and then in front of the Commonwealth Court against Lower Merion Township in relation to their zoning regulations that basically precluded Pennsylvania firearm sales licensees and Pennsylvania federal firearms licensees, except for in very limited zoning districts. And you basically had to stand on your head to potentially become compliant. And then they could still tell you, yeah, although we said in these districts you could potentially do it, we still have the right to say no. And so that case has the larger possibility, I think, of the court taking it up because Lower Merion Township has petitioned for allowance of appeal before the Supreme Court to hear the case. And I think that one may lend itself better to the field preemption argument. And in fact, that is part and parcel of how the Commonwealth Court decided the case based on field preemption. So that's a little bit about the hearing today. I would say if I was trying to read the tea leaves, we have Justice Brobson, Justice Wecht, Justice Mundy definitely in support of preemption. Again, whether it's under express or field, I think it's more likely going to be under express. Under express preemption, it seemed like Chief Justice Todd was in agreement with that type of argument. So that would be your fourth vote and give you a win. Justice Dougherty seemed concerned. He kept raising the issue beyond how manufacturers encompassed in 6120 without it being stated, with 12-year-olds being able to purchase a 3D printer and be able to print their own firearms and take them to school. Even though counsel for GOA did correctly note that that's illegal. We have a law that prevents minors, generally speaking, from being in possession of firearms except for in limited circumstances. That didn't seem to allay Justice Dougherty, although I'm not sure what an ordinance is going to do to prevent such conduct if misdemeanors and felonies doesn't prevent such conduct. In relation to Justice McCaffrey, the newest justice on the Pennsylvania Supreme Court, he also seemed to be aligning himself more with Justice Donahue in that he did not seem to believe that preemption maybe should exist here in the Commonwealth, or to the extent it does, it should be reined in. So I think it's going to really depend on exactly what the court decides to do in this situation and what justices decide to align themselves in what specific scenarios.
Well, and that's dangerous for us too, right? Because I mean, I don't know why GOA, not to knock them or attack them for what they've done presenting this case, but you've used preemption, even field preemption, the express implication of field preemption coming from that Supreme Court ruling repeatedly to beat ordinances all across the Commonwealth here. So they don't seem to go after it quite like you do, and I think that's a mistake. But I wish you were up there making the argument. I'm glad you filed the brief in support. Hopefully they read that. I think that your work is known by most of the justices there, and I think they will probably give it its due credit, reading through it at least to consider it for the case. So that's what we hope. It worries me when you have these Supreme Court justices sitting there going, well, we're not really sure. We disagree with that. They can disagree with it on a personal level all they want, but their court opinion needs to be what the intent of the Commonwealth was, what the General Assembly was, and we've provided transcripts for that on some of these cases. So I'm hoping that they give your brief the weight that it deserves, and we'll see where we go from there.
There is a separate issue that was raised, and this was raised by Justice Brobson, and that is, when is a firearm actually a firearm? And how are we going to define, when preemption would apply? If we assume it applies to firearms, does it apply to firearm components? Does it, even if so, what is a component? How do you decide if a hunk of metal is yet a firearm or not? And he even brought up, knowing I was in the gallery, that when he was on the Commonwealth Court, and then Attorney General Josh Shapiro had passed his opinion regarding partially manufactured frames or receivers, and then the Pennsylvania State Police decided to institute it, that he sat as the presiding judge hearing that preliminary injunction hearing, and having to decide, was this a step too far? What were they regulating? And did it constitute a firearm, or was the definition enacted by the General Assembly contrary to their position? So I thought it was interesting that he decided to raise it. But again, he raised it in the context of, we're going to have to decide at some point what all is actually protected under our preemption statute, even if you look at it from a field preemption perspective. How much does it have to touch upon a firearm or the firearm regulations to be preempted? Again, if they prevented anyone in the city of Philadelphia from being able to purchase a 3D printer, while it would have implications of preventing the manufacture of a firearm, because they're just blanketly prohibiting the purchase of 3D printers, would that be acceptable? Mm-hmm. Or do you have to have a statement from the enacting body saying something like, we are going to ban 3D printers because we don't want them to be utilized for the manufacture of firearms?
And then at that point, you've got your Second Amendment challenge, right? Because we've seen the U.S. Supreme Court rule on that, stating that unless it is a primary kit, an assembled kit that's ready to assemble all together, that it's protected activity. So I guess that would change the argument if we ever get to that. Hopefully, it's not something we have to worry about.
Yeah, and again, only time will tell, but I do think it's really important that we be very selective in the types of preemption cases we bring. I know, having worked with FOAC for decades now, that a lot of thought goes into the types of cases that we're going to bring and the order in which they're brought, so that we can build upon each case and the precedent established by those cases, instead of going so far that it makes it easy for the court to rule against us. And once that negative precedent's out there, you better believe that the gates will open up, and every municipality throughout the Commonwealth is going to be doing whatever they can to try and enact some form of ordinances. And to some extent, after the challenge was filed in Philadelphia and lost before the Philadelphia Court of Common Pleas, that's when then all of a sudden we saw other municipalities like the city of Reading and that passed these identical ghost gun ordinances to Philadelphia, because they felt that now they could do that, even though it's not going to change anything. It's not going to prevent any crime or anything of that nature. And unfortunately, it didn't really get discussed today at argument. But prior to 1968, there was no requirement for serial numbers. That aspect was discussed today during oral argument. But all the firearms that exist out in commerce that don't have serial numbers because they existed before 68 are a monumental number. And let's be honest, the ability to trace a firearm doesn't generally result in any preclusion of crime occurring, and it's extremely limited in the occasions where it actually helps solve any crime. So I think it's really a red herring with just an ability to regulate in some manner law-abiding citizens.
Clint, I think we've talked before. We actually have a statement from the state police commander at the time or commissioner at the time, stating that in over 100 years of record keeping, they think it may have helped solve 4 crimes. So that tells you what serial numbers are worth. So we appreciate you going out there, doing the dirty work for us. I know it's a lot of work. Some of these briefs that you write are pretty intricate, and you spend a lot of time, helping us walk through these things and dealing with the courts. I appreciate you taking the time. So you make sure you have our appreciation and our respect for what you do.
Absolutely. And I don't know if it's possible, but maybe if so, you can put a link out on the video or that. So if anyone wants to download a copy of the brief that FOAC submitted to look at it, and if you're in a position to donate to help FOAC, please do that. All your dollars go directly to these types of cases. As Jim will tell you, he doesn't get any money. No one in FOAC gets paid. It's all volunteer.
We spend a lot of our own money.
Yeah, it costs me quite a bit. We call it our war chest. So all good. Klint?
Yeah, I mean, it just goes to show when it comes to pro-gun pursuit in the court, in the legislature, in the hearts and minds of people, you can't play Tasmanian devil, man. It's a chess game. We got to think long game on this, and I hope that the brief that you created, Josh, is heeded, and that helps GOA in their case, because I'd hate to see this bad precedent get extended, and we have to fight it tooth and nail moving forward, more so than we already have. As you said, since that ruling came out, all those municipalities all over the place were passing these ordinances that would, I believe, or violate preemption based upon what we've seen and what we've done. But yeah, folks need to understand that the long game is in the courts, and the long game, incrementalism does work. I mean, we've seen, from the U.S. Supreme Court, Pennsylvania Supreme Court, how we've slowly been chipping away and getting rights back to our fellow Americans and Pennsylvanians, but it takes time and money. So please donate and become a member of FOAC, and we'll see you maybe at the bash this weekend too.
Great. Sound good, gang. Josh, thanks for your time. Klint, thanks for taking the time. I know you're busy today with training, and appreciate you both coming here to discuss it.
Yeah, thanks,
My
guys.
pleasure.